Welcome to the Deep Dive. Today we're taking a fascinating journey into Margaret Davies' book, Law Unlimited. Think of this as your shortcut to a fundamentally different way of understanding law, one that moves beyond the usual constraints.
Yeah, breaking out of the box a bit.
We'll be exploring her 2017 work, published by Routledge, drawing out the key ideas to see how law might be more dynamic, more material, and surprisingly plural than we typically imagine.
Exactly. Whether you're brushing up on a field, prepping for a discussion, or just, curious, we want to give you those real aha moments
Right.
by unpacking some pretty complex ideas in an accessible way. And Davies' work, it really makes you reconsider the boundaries we often just take for granted when we think about law.
Absolutely. We're talking about questioning whether law is always tied to the state, or specific institutions, or even fixed definitions.
Yeah, all those standard assumptions.
She challenges us to think about whether law is always a conscious human creation, and if it's truly separate from, well, politics and morality.
Which is a big one.
Our goal is to delve into this idea of unlimiting law, temporarily setting aside those familiar boundaries to gain, a fresh perspective.
And it's important to say, Davies' main goal isn't really to give us a shiny new definition of law to memorize.
Okay.
Instead, she wants us to examine what happens when we start to question some really deep-seated distinctions in Western thought.
Like what specifically?
Like the divisions between our minds and the physical world, between culture and nature, and between ourselves as subjects and the things we see as objects, these big divides.
Okay, let's unpack this. Davies structures her book to guide this exploration. She starts by looking at theoretical limitations.
Right. The constraints we put on our thinking.
Then dives into the concept of materialism, considers scale and perspective, examines the role of metaphors and meaning, explores the relationship between law and the self, and then brings it all together in her conclusion. It's quite a comprehensive exploration.
It really covers a lot of ground.
And it's important to remember that Davies is a respected legal scholar, and some of the ideas in Law Unlimited have grown from her earlier work, in publications like Jotwell and other legal journals.
That's right. These ideas have been developing over time. So let's start with those theoretical constraints she identifies.
Okay.
One of the first things she looks at is this long-standing tension. On one hand, you have the modernist preference for neat, orderly, coherent theories.
Everything fitting nicely together.
Exactly. And on the other hand, you have pluralist thinkers like, say, William James, who really emphasize the inherent complexity of the world. A complexity that doesn't always fit neatly into our conceptual boxes.
Right. And here's where it gets really interesting, I think. It's not just about whether there are multiple legal systems out there in the world.
No, it goes deeper.
Davies takes it a step further. She argues that the very idea of pluralism fundamentally challenges our notion of having certain knowledge about law, its core nature, its ontology, even where we might find it.
Exactly. So it's not just about acknowledging different types of law existing side by side. It shakes up what we think law fundamentally is.
And a central part of this challenge comes from that traditional Western separation between subjects and objects.
Yes. That way of thinking often traced back to Descartes. This is the idea of our minds as these separate mental things, distinct from the physical world, matter that just takes up space.
Consciousness becomes the dividing line.
Right. Consciousness creates this fundamental divide between us as thinking beings and what we perceive as a separate, often passive, natural world.
So if we humans are the thinking subjects, then everything we create, our culture, is seen as fundamentally different from nature.
Yeah, it sets up this kind of total system, almost, with a clear inside and outside. Culture over here, nature over there.
But Davies highlights the growing influence of materialism as a real challenge to this Cartesian dualism. What's the core shift in perspective there?
Well, the core shift is moving away from seeing mind and matter as fundamentally separate substances. Materialism, in this context, suggests that everything, including consciousness, actually arises from material processes.
Okay.
And this has gained a lot of traction in fields like material culture studies, actor network theory, thing theory, object-oriented ontology, quite a few areas.
Right.
The key insight for our discussion is the idea that law isn't just an abstract set of rules floating around. It's actually embedded in the physical world. It emerges from how humans interact with that world.
So things like legal geography.
Exactly. Scholars like David Delaney even coined the term nomosphere to describe this intersection of the social, the material, and the legal. It's where law happens, in a sense.
Right, so it's the idea that we aren't just these minds floating above a physical world that law then governs from on high.
No, not at all. We share our physical existence with everything else, organic, inorganic.
Yeah.
And this matter isn't just passive stuff waiting for us to act on it.
It has agency.
In a way, yeah. It has its own vibrancy. It acts within our world. It's part of the relationships that shape law. Materialist scholarship puts us humans within these networks, but not necessarily at the top or in the center.
More like a flat web.
Kind of, yeah. A flat web of connections involving humans, animals, plants, the environment, even non-living things. Everything's interconnected.
Exactly. And this raises a really important question for how we think about law. Do we keep trying to separate human-created social structures and see law as existing only within our human sphere?
Or can we see it differently?
Right. Davies points out that defining law in a single specific way isn't a neutral act. It's a politics of definition, she calls it.
Yeah, and that inevitably favors one tradition, one way of seeing law, and pushes others to the margins. It empowers certain views.
And going back to William James's idea of pluralism, what's the key element that challenges this singular view of law?
The key element is this idea of irreducible otherness. Pluralism, as James defined it, suggests that nothing can ever fully encompass or dominate everything else.
Something always escapes.
Something always escapes our attempts to create these complete unified systems. It's really the direct opposite of rationalist and idealist approaches that try to carve out neat, singular concepts from the messy, continuous flow of our experiences.
So instead of searching for that one perfect definition of law, pluralism embraces the idea of inherent diversity and irregularity. It accepts the messiness.
Precisely. You could think about Karen Barad's concept of the world being made and understood through agential cuts.
Agential cuts.
Yeah, imagine carving up a landscape. The way you divide it creates different areas and boundaries. These cuts are contingent, meaning they could have been made differently, right?
Okay.
And they're not fixed or absolute. So the systems and unities we create, including our understanding of law, are shaped by these particular and potentially different ways of dividing things up.
So the way we categorize shapes what we see.
Exactly. The choice between a pluralist perspective seeing many possibilities and a monist one seeking a single unity becomes almost a fundamental attitude or orientation.
And in the context of law itself, it sounds like the initial push to recognize this kind of pluralism actually came from outside the traditional legal field.
That's absolutely right. It was largely anthropologists and sociologists who were observing this wide variety of normative orders in different societies.
Seeing how different cultures handled rules and disputes.
Exactly. They were the first to really highlight the existence of legal pluralism. And this was in stark contrast to the legal profession's own deeply ingrained assumption of a single, unified legal system centered on the state.
Okay, moving on. Davies talks about conceptual dynamism. What's the core idea there?
The core idea is that our concepts, the fundamental building blocks of our understanding, they aren't fixed and immutable. They're not set in stone.
They can change.
They can change. Davies suggests we might be in a period of significant change, maybe even a paradigm shift, where it's actually okay to move away from this constant pursuit of perfect theoretical coherence.
So letting go of the need for everything to fit perfectly.
Yeah. And the challenges we face aren't just about human subjectivity anymore. They're expanding to include the agency and perspectives of non-human entities as well. Posthumanism, that sort of thing.
So legal theorists need to be open to the idea that law isn't just one thing, and that even our fundamental ways of understanding it might need to evolve.
Right. Be more flexible.
And this brings in the context of the Anthropocene, this era where human actions are significantly shaping the entire planet. How does that demand a new kind of thinking about law?
Well, the Anthropocene really forces us to confront the undeniable interconnectedness of nature and culture. Traditional Western philosophy and theory have often operated with a fairly clear separation between the two.
Right. Nature over here, culture over there.
But the environmental crises we face make it impossible to ignore their entanglement. They're deeply interwoven.
We can't separate them anymore.
Exactly. And this demands that we re-examine our existing concepts and potentially develop new ones to better grasp this reality. It makes us ask, what exactly is a concept? Are we just trapped by the ones we've inherited? Or can we actively shape them to better understand our changing world?
Davies points out that contemporary theory is increasingly drawing inspiration from thinkers who emphasize this very dynamic nature of concepts, their ability to adapt to altered circumstances.
people who saw concepts as more fluid.
So the idea that the goal of theory is to construct these timeless, enduring concepts is being challenged.
Right, maybe that's not the only goal or even the main goal anymore.
So how do these new concepts actually come into being? What does that look like?
Well, we see new concepts emerging in a variety of ways. Sometimes it's by combining existing ideas, creating hybrid terms like material semiotic, blending the material and the symbolic or nature culture.
Smashing those two together.
Exactly, collapsing that divide we just talked about. Sometimes it's through the use of metaphors that take on new meanings and reference. Think of the idea of a rhizome as a non-hierarchical network.
Or even just network.
Or network itself, yeah, to describe complex interconnections. Existing terms can also be expanded and nuanced, like subaltern to describe marginalized groups, or actant to describe anything, human or non-human, that has agency within a system.
Right.
And quite often, concepts are borrowed and adapted from other fields, particularly from science. Things like autopoiesis, which describes self-regulating systems, or ideas around evolution.
So while concepts can be quite adaptable, Davies also uses Wittgenstein's analogy of the riverbed to remind us that the underlying foundations of our thinking are maybe more resistant to change. Can you explain that?
Certainly. Imagine a river flowing. The water is constantly moving and changing, right? Just like our individual concepts can evolve. However, the riverbed itself, the deep underlying structures of our Western philosophical and cultural knowledge, the assumptions we barely notice, that's much more stable and harder to reshape. It provides the channel, the banks, within which our conceptual changes tend to occur.
So there are deeper structures that are harder to shift.
Exactly. There's inertia there.
And it's important to remember that we often think of conceptualization as a process of abstraction, finding those general principles that unite diverse things, bringing order and coherence.
That's the standard view.
But Davies, drawing on Adorno, reminds us that a purely abstract concept can be limiting. How so?
Well, a purely abstract concept, by its very nature, tends to exclude the specific details, materiality, the emotions, the dynamic, ever-changing aspects of whatever it's trying to describe.
It smooths things over.
It smooths things over, yeah. It focuses on what's general and overlooks the richness of the particular. Adorno argued that by stripping away these non-conceptual elements, we actually lose a crucial part of understanding. We miss the nuances.
That leads to the idea of thinking about concepts not as these fixed universal truths, but more as experimental explanations.
Yes, like Deleuze and Guattari put it, that philosophy is fundamentally about creating concepts, not just discovering pre-existing ones.
And Davina Cooper adds another layer to this, highlighting the interplay between our imagined worlds and our actual practices.
Exactly. Cooper suggests that concepts are constantly oscillating, bouncing back and forth between the realm of imagination and the realm of practice.
So they influence each other.
Right. Our desire for social change can certainly fuel the development of new concepts, allowing us to imagine different ways of being and organizing society.
Thinking about what could be.
But at the same time, our existing practices and the structures of the world around us can also constrain our conceptual imagination. They can limit what we can even conceive of as possible. Practice shapes thought, and thought shapes practice.
This brings us to the fascinating idea of prefigurative law and theory. What exactly does that mean?
Well, Davies argues that theory isn't just about passively describing the world as it is. It's also performative, it does something, it acts upon and shapes the world.
How so? Give me an example.
Think about legal theory. It responds to the social and cultural conditions of its time, right? And it becomes more established, more solidified through repeated affirmation. Legal positivism, for instance, gained dominance partly through this process of reiteration and acceptance.
Okay, so it reinforces itself. But theory can also be a form of enacting a desired future, right? It can push against the status quo.
Precisely. This is where the idea of prefigurative theory comes in. It's about acting in the present as if a future state of affairs already exists.
Like being the change.
Exactly, like being the change, as activists often say. They embody the kind of change they want to see through their current actions. Theorists can do something similar. By identifying aspects of the present that point towards a desired future, maybe focusing on sustainability or relational identity, and then amplifying those aspects through their theoretical work, they sort of prefigure or model a world organized around those values.
So it's about intentionally highlighting and theoretically strengthening the seeds of the future that already exist, even if they're small, in the present.
Exactly. And as John Law and John Urey point out, we need to recognize that scholarly activity is never a neutral observation. It inevitably intervenes and shapes reality. We can't help but make certain aspects of the world more visible and influential just by focusing on them.
So we have a responsibility there.
Right. The crucial question then becomes, what kind of reality do we want to help bring into being through our work?
Looking back at the history of ideas, we can see examples of this future-oriented nature of theory, can't we?
Definitely. Locke's two treatises of government, for instance, wasn't just about the political conflicts of his day. It also laid the groundwork for arguments supporting colonialism and individualism that shaped things for centuries. Similarly, Austin's work on positive law wasn't just a description of what law was. It played a role in solidifying its dominance as a particular way of understanding law. It helped make it seem like the only way.
So transformative theory goes beyond just describing the status quo.
Oh, yeah. It's analytical, it's critical of existing conditions, it's often idealistic in its vision, aspirational in its goals, performative in its impact, and sometimes even utopian in its scope.
And it might even strategically misrepresent the present. That sounds counterintuitive.
It does, but think about it. It might misdescribe the present or maybe selectively focus in order to highlight the potential for a different future.
That's a key point, this idea of potentially misdescribing the present to bring out transformative potential. Can you elaborate on that with Austin again?
Sure. Think about Austin's description of law as simply the command of a sovereign. Now, while this might not have perfectly captured all the nuances of law, even in his time,
It was a simplification.
it was a simplification, yeah. But it was also an aspirational definition. It helped to solidify a particular understanding of law as positive law explicitly laid down by a recognized authority. It wasn't just a neutral observation. It was an intervention aimed at shaping how law was understood and practiced going forward.
And the criticisms often leveled against critical legal theory for not offering fully formed alternative models.
Exactly. Those criticisms often miss the point, according to Davies. Conceptual change doesn't usually happen through the sudden creation of a complete, perfect blueprint.
Messier than that.
It's much messier. Instead, it arises from the accumulation of smaller shifts across various domains. Practical actions, scholarly work, activist interventions, all often accelerated by broader historical conditions. The history of positivism itself demonstrates how influential an approach can be, even if it simplifies or selectively emphasizes certain aspects of reality.
So critique itself can be prefigurative.
Yes. Davies argues that there is a significant, often overlooked element of this kind of prefigurative practice already at work within feminist and critical legal theory.
Okay, now let's delve into the central theme of limited and unlimited law. Davies starts by questioning some of the most fundamental assumptions that legal theorists make. What are some of these key presumptions?
Well, one of the most fundamental is the assumption that there must be a single overarching concept of law. You know, this one idea against which all other forms of social ordering are measured and usually found wanting.
The gold standard.
Right. Davies asks us to consider, can we actually move beyond this need to define law as one coherent totality? Do we need that single concept?
And she also challenges the very idea of what a concept of law even is in the first place.
Precisely. It's not just about the content, but the nature of the concept itself. Davies emphasizes that there are many different ways of understanding law beyond the perspective of the legal expert or the socio-legal observer.
Like how?
Well, we need to consider how law is experienced in everyday life, how it's shaped by and shapes our physical environments. That's the focus of legal geography, and the often invaluable insights that come from empirical approaches like legal anthropology, which studies law in diverse cultural contexts. These often get sidelined in traditional legal theory.
So while the descriptions offered by state law theorists might be relevant at their specific level of analysis, say, for understanding Western state law from an insider's viewpoint.
Right. They provide a particular localized understanding. That's fine as far as it goes. But it becomes problematic when theorists then try to claim that law is simultaneously just this specific social phenomenon and that it possesses some universal unchanging essence. That's the leap she questions.
And sociologists of law have maybe been more comfortable with context.
Generally, yes. Sociologists of law have tended to recognize that any concept of law is inherently contextual, and that empirical analysis requires more flexible provisional ideas of what counts as legal in a given situation, not a fixed universal definition.
And once you look beyond the state, this underlying disunity in our ideas of law becomes even more apparent.
Absolutely. If you impose a single master narrative of legality, the idea that there's one true form of law, usually the state's version, you actually obscure the rich empirical diversity of how norms and rules function in different social settings.
It hides things.
It hides things.
Well,
Brian Tamanaha even argues that the reason why we've never been able to definitively capture the essence of law is because it simply doesn't have one. There's no single core.
Davies then points to the dominance of what she calls methodological statism in legal theory. Can you explain what that entails?
Sure. Methodological statism is basically the deeply ingrained assumption within legal theory that law is fundamentally and inextricably linked to the nation-state.
That's just the default starting point.
It's the default, yeah, largely based on the historical development of law in Western Europe. This assumption leads to legal theory primarily focusing on the task of describing and analyzing the law of the state. Thinkers like Kelsen and Austin, despite their differences, both largely operated within this framework.
Even Hart.
Even H.L.A. Hart's influential work, with its emphasis on the rule of recognition, implicitly presumes a state-based legal system is the primary object of study.
And in a way, this creates a kind of parallel between the idea of the sovereign state and the idea of the autonomous individual in Enlightenment thought.
That's a very insightful connection Davies makes. The Enlightenment subject, conceived as sovereign, self-determining, autonomous.
The rational individual.
Right. That becomes a kind of mirror image of the law state, which is also imagined as sovereign and self-contained, almost like scaled-down versions of a monotheistic God, capable of creating and enforcing its own rules independently.
And this leads to the law state being treated as this abstract entity with its own independent agency, separate from the people involved.
Exactly. It becomes reified, treated as a concrete thing with its own will and power, separate from the actual human beings and social interactions that constitute it.
We even talk that way.
We do. We see this even in critical writing, where law is often personified, spoken of as if it has its own intentions and actions. The law does this, the law requires that, even though positivist status law is ultimately just a particular formalized subset of human social life.
Althusser's ideas fit here, too.
Yes, Althusser's concept of ideological state apparatuses, including law, and the idea of legal subjects being interpolated or called into being by an imagined law, captures this process of how we come to see ourselves in relation to this reified idea of law.
The connection to physical space also seems significant here. How does that work?
Absolutely. Law is frequently represented and understood through spatial metaphors. Think of boundary lines, maps of legal jurisdictions, the very concept of legal scale we'll get into later.
Yep.
However, Davies argues that the traditional conceptualization of law has often been achieved by actively excluding the social world, individual experiences, relationships, and the physical environment, essentially, by excluding real-world materiality and factual presence.
So it becomes detached.
It becomes detached. Even territorial metaphors, which seem grounded in place, can contribute to this exclusion by framing law as these abstract insides and outsides that exist somehow outside of time and specific locations. Detemporalized, she calls it.
But it's not as if mainstream legal theory presents a purely top-down view of law, right? Doesn't it acknowledge other actors?
No, that's a crucial point, and Davies acknowledges it. While the state-centric perspective is dominant, legal theory does also recognize that positive law is constituted by various actors beyond just state officials.
Like who?
Well, the community itself, those who habitually comply with the law, as Hart and Waldron have noted. Even Dworkin's idea of law as integrity, which involves a personified legal community and an ideal judge interpreting legal traditions, acknowledges a broader context for legal interpretation, even if it's an idealized one.
What's really striking, though, is how these different perspectives, the pluralist, the critical, the empirical, seem to be converging somehow.
You're right. There's a fascinating convergence happening. You've got the empirical observations of socio-legal pluralism.
Seeing law in practice.
Seeing law in practice. Then you have the anti-essentialist stance of critical legal theory, saying there's no single essence.
Right.
And the conceptual innovations coming from various other fields like materialism and post-structuralism. This convergence characterizes legal plurality not as a collection of separate static systems, but rather as a dynamic, ongoing process.
What does that process look like?
It's seen as open-ended, constantly being interpreted and reinterpreted, shaped by everyday relationships, deeply contextual, personal in its impact, dialogical in its operation, and ultimately something that is actively practiced, not just passively received.
And this dynamic view also challenges traditional positivist theory's strict separation of law from morality and its grounding of law firmly in the present moment.
Precisely. Critical reimagining sees law as much more temporally complex. It blurs the lines between the present and the future and challenges the rigid separation between what is descriptive statements and what ought to be normative statements.
The famous is ought gap.
Right. Davies argues that descriptions of law are never truly normatively neutral. Even stating what is often carries an implicit directive, suggesting how things should be understood or acted upon. It subtly shapes the ought.
So the very act of describing law has a kind of performative effect. It does something.
Exactly. The is isn't just a neutral observation of the present, it's also constitutive of what can come next through our participation in collective discourse and interpretation.
Like Austin again.
Like Austin again. His seemingly straightforward description of law as the command of a sovereign wasn't just a factual statement, it was also aspirational. It played a role in establishing and reinforcing the idea of law as positive law in his time and beyond.
So what are the crucial insights here?
The crucial insights are, first, that what we perceive as is can often contain an implicit ought, and second, that any concept of law we hold is ultimately performative. It contributes to the very reality it seeks to describe.
So descriptions lay down rules for interpretation.
Exactly. Descriptive statements about law inevitably become normative in practice, laying down rules of interpretation that influence both our thoughts and our actions. Observation itself, as the saying goes, is theory-dependent. You can't purely observe without some framework.
Okay, let's turn our attention to this idea of the norm. Davies seems to be using a very broad definition here.
Yes, she does. It's quite expansive. For Davies, a norm isn't just a formal legal rule like a statute. It's any kind of guide that influences behavior. And importantly, this includes our thoughts as well.
What are the traditional sources legal philosophy looks at?
Legal philosophy has traditionally focused on three main sources of norms: custom, command, and moral standards.
Right.
Custom being those repeated behaviors that gradually solidify into accepted, often place-specific standards. Think common law origins.
Okay.
Command being a specific act of will by a recognized authority, a sovereign or lawmaker, very central to 19th and 20th century legal systems.
And judicial decisions.
Judicial decisions kind of occupy a space somewhere between custom and command. They interpret past practice, but also issue directives.
And Davies wants to bring the idea of custom back into the forefront of legal theory, but maybe with a more expansive understanding.
Exactly. She wants us to think of custom not just as old, unchanging traditions locked in the past, but more broadly as the ongoing repetition of behaviors and discursive patterns, ways of talking, ways of acting that gradually solidify into what we recognize as law.
But custom often sounds conservative.
It does, and it's often associated with conservatism and preserving tradition. But its core mechanism, repetition, is actually about both maintaining sameness and allowing for subtle differences and change over time. Repetition is never exactly the same.
And she suggests maybe replacing the term custom with other concepts to capture this more dynamic and material understanding.
Yes, by using terms like performativity, narrative, and iteration, Davies aims to promote a more materialist and embodied image of law, one that emerges from our actual social relationships and practices, not just from abstract reason or sovereign will.
So where does law exist in this view?
Law, in this view, becomes embedded in the micro-actions of our daily lives. It's iterated constantly, but never in exactly the same way or in the same context. It can be found in unexpected places.
Right.
Like in our physical and even neurological pathways, the cultural narratives we tell and retell, and the very language we use, in our material bodily actions, and even in our relationships with the non-human world. It's much more diffused.
This leads to a revitalized understanding of usage as performativity and iteration as being central to how norms come into being.
Precisely. Davies argues, and this pushes back against someone like Kelson, who insisted on a sharp separation between the I's and the ought, that there is a norm in normal.
A norm in normal.
Yeah. What we consider normal, the convergence of certain behaviors, ways of speaking, meanings, symbolizations, or actions, exerts a powerful gravitational pull. It often gets accepted as an unquestioned presumption, a baseline.
And this normativity isn't simple.
Not at all. This kind of normativity is incredibly complex, dynamic, and multi-layered. It can't be reduced to a simple system of rules or prescriptions handed down from above.
Within this broader understanding of norms, Davies also brings in Ruzi Brodati's concept of human normativity. What does that highlight?
Brodati's concept draws our attention to the idea that the human itself is not a neutral or natural category. It's actually a normative convention.
How so?
It's a specific way of being, often based on a particular kind of privileged human that has been elevated into a generalized standard, the human. And this standard is then often constructed in opposition to various others, those who are sexualized, racialized, naturalized, or even technological artifacts. It reveals how power operates through the very definition of what we consider normal or properly human.
And Claire Colebrook offers a subtle but important distinction between the normative and the normal.
Yes, Colbert distinguishes between the normative, which refers more to regulatory ideals and explicit rules we consciously follow, and the normal, which she defines as a state of similitude, of likeness, based on a preceding and determining life or pattern.
So it's less about choice.
It shifts the focus perhaps from self-determination and conscious choice, the normative, to alignment with a pre-existing standard, the normal. It changes the underlying value system, the axiology.
And this brings us back to the difficulty of even naming non-state law
Yeah.
and that blurry line between describing law and simply describing social life.
Exactly. If law isn't exclusively tied to the state, and norms operate in all these different subtle ways within our social interactions, where do we draw the line? When does a pattern of behavior become a form of law, and when is it just part of the broader fabric of social life?
Tough questions.
They are some of the challenging questions that arise when we move beyond that comfortable state-centric view of law.
Okay, let's move on to legal materialism and social existence. Davies uses materialism in a few different senses here. What are the key aspects she's focusing on?
Right. She uses materialism to encompass a few related ideas. First, the idea that material factors and conditions, economics, environment, technology, bodies play a significant role in producing law as an effect.
Yep.
Second, that there's a dynamic and ongoing relationship, a back and forth, between what we discursively separate as law, the rules, the concepts, and the broader social sphere, lived reality practices.
They're not totally separate.
They're not totally separate. And third, the more radical claim that law is itself fundamentally material, not just an abstract set of ideas that gets applied to the material world.
And that challenges the traditional view.
It absolutely challenges the traditional view in legal theory that situates law primarily in the realm of the immaterial as some kind of distilled essence or nature that exists apart from its various concrete manifestations in documents, buildings, actions, etc.
State law, for example, is often thought of as this abstract body of rules that is derived from material sources like cases and legislation through processes of interpretation and reasoning.
Precisely, that's the standard picture.
Yeah.
But Davies questions the nature of this abstract law and how it relates to the concrete realities of social life.
How does she question it?
She draws on concepts like Bourdieu's theorization effect, which describes how an initial theoretical response, an abstraction, can become a fixed framework that then shapes and limits our understanding going forward.
Or Hale's idea.
Or N. Catherine Hales's idea of the Platonic backhand, where an inductive observation drawn from material reality is then flipped and treated as a definitive pre-existing schema, potentially obscuring the ongoing dynamism and complexity of the reality it came from.
Feminist theory has also made significant contributions to this discussion by focusing on the body, hasn't it?
Absolutely. Feminist theory has brought critical attention to the body not as a fixed biological entity, but as something that is both socially constructed and actively generative of knowledge and social meaning.
Challenging those old dualisms.
Exactly. Challenging the long-standing dualistic thinking that has often aligned women with nature and the body and men with culture and the mind. By emphasizing that our subjectivity is embodied, feminist thought has pushed for non-dualistic accounts that question traditional separations like subject-object and nature-culture.
And in legal feminism, this has meant challenging the sharp distinction between law and the body itself.
Yes, legal feminism has illustrated in numerous ways how bodies are not just passive recipients of legal regulation. They're not just things law acts upon.
They act back.
In a sense, yes, bodies are also actively involved in the creation and operation of law within broader material social networks. Think about laws around reproduction, identity, disability. The body is central.
And Althusser's concept of ideological state apparatuses fits here too.
It does. Althusser's concept, which includes law, helps us understand these as material organizations, courts, schools, families, etc., that produce and reproduce dominant ideologies and actively construct us as subjects within those ideologies.
And for Althusser, ideology wasn't just about having the wrong ideas or false consciousness, right?
Exactly. That's a common misunderstanding. For Althusser, ideology wasn't simply a set of incorrect beliefs. Instead, he argued that it was fundamentally material.
How is an idea material?
It's inscribed in our everyday practices and rituals. It's performed by us as subjects, often unconsciously, and it's maintained through the institutions that govern our lives. The process of becoming a subject through interpellation, being hailed or recognized by ideology, like when a police officer says, "Hey, you," is a deeply bodily, social, and psychological experience. It's not just in the head.
Postmodern and post-structuralist thinkers also engaged with this idea of materiality, didn't they?
Yes, many of them were very attentive to the interplay of matter and ideal, the social body, and abstract concepts. Their explorations of ideology, language, myth, signification, you can understand all of these as investigations into these material semiotic processes, how meaning gets created and fixed or unfixed through material forms and practices.
But Davies suggests this didn't always challenge the core divide.
Well, she notes that within legal theory, this engagement with materiality sometimes led to an overemphasis on the contingency and fallibility of the real, which paradoxically might have reinforced the distinction between the ideal realm of law and the messy material world, rather than fully contesting it.
Okay, this brings us to the idea of a new legal materialism. What's different or new about this approach?
The new legal materialism, as Davies describes it, delves deeper into some really fundamental questions. It asks about how we understand society itself. Is it just humans or a more complex assemblage? And crucially, how do we as human subjects and knowers understand our own place within that world?
That Heidegger question.
Exactly. Do we as human entities exist prior to the world as independent subjects looking in from the outside? Or are we, in a sense, created by our interactions within it? Are we fundamentally in the world, not separate from it?
And how is legal theory engaging with this new materiality? Where do we see it showing up?
Legal theory is addressing this in several important ways, with legal geographers playing a particularly prominent role. They really focus on situating law within specific physical spaces.
How law shapes places and places shape law.
Exactly. Highlighting how law actively shapes our spatial environments. Property law creating boundaries, planning regulations dictating land use, environmental law managing resources, but also how law is itself deeply embedded in particular places. It emerges from the specificities of those locations and the material connections that exist there.
Like the enclosure movement or colonialism.
Precisely. Those are examples where universalized conceptions of law, often detached from place, displaced more place-based forms of regulation, frequently with significant and often destructive consequences. This perspective really emphasizes the ongoing entanglement of law with specific spaces and localities. It's not abstract.
Another key aspect seems to be the focus on relationality.
Absolutely. There's a growing emphasis on the various kinds of relationships that exist in the human world, things like resistance, mutual reliance, exclusion, cooperation, conflict, and how these relationships actively shape both subjects and objects.
Actor network theory comes in here.
Yes, actor network theory, ANT, is a key framework here. It explores how agency isn't just located in individual humans, but emerges from the interactions within these complex networks of both humans and non-humans, technologies, animals, documents, microbes, etc.
This reminds me of Michel Serres' concept of the quasi-object. Can you explain that and its relevance to law? It sounds intriguing.
It is. Serres uses the concept of the quasi-object to describe an interactive object that's something that passes between people that, through its movement and exchange, actually defines the subjects involved and creates a sense of we, a collective.
His example is a ball game.
Yes, his famous example is a ball in a game. The ball itself is nothing without someone to interact with it, right? But at the same time, the skilled players become defined by their relationship to the ball. They almost become extensions of it. Serres calls this a Ptolemaic revolution, where the body becomes the object of the ball's movement, anticipating it, reacting to it.
And the person with the ball.
The person holding the ball might become a target, with the ball becoming like a hot coal that needs to be passed on quickly. This constant movement and interaction between the players and the ball is what creates the game. And in the process, it shapes the subjects, the players, and the object, the ball, simultaneously.
So it's challenging that traditional Cartesian idea of a clear separation between a thinking subject and a passive, inert object.
Precisely. Descartes separated mind, thinking, perceiving, from matter, extended, passive, often doubted. Serres's ball game illustrates that the subject isn't a pre-existing entity simply acting upon an object. The subject is partly an effect of the game itself, with meanings and identities emerging from this dynamic, ongoing engagement between body and object, a material semiotic process. Meaning and matter are intertwined.
And this seems to be the common thread running through this new materialism.
Yes, I think so. The common element is the move away from a purely human-centric view of the world. It's about situating humans within a broader material reality where all matter is interconnected, where objects possess a certain vitality or agency of their own, and where agency itself emerges from these relationships rather than being solely located in individual autonomous subjects.
But this raises a challenge for imagining a materialist legal theory, doesn't it? Given that law seems to rely so heavily on distinguishing between subjects who have rights and passive objects, which are property.
That's a crucial point, a real tension. How can we reconcile this materialist view, where agency is distributed, with law's seemingly inherent need for that subject-object differentiation?
How does Davies address that?
Well, Davies argues that law, even abstract state law, is always perceptible by the senses through acts of performance, speaking, writing, reading, hearing, discussing. There is simply no law without these material acts.
It has to manifest
It
something.
has to manifest. Even state-based law, which often seems abstract, is almost always written down. Social norms materialize in observable patterns of human relationship and behavior. The process of law becoming material, the writing, the speaking, the building of courts, is often seen as secondary, just a medium for communicating pre-existing abstract laws.
But she challenges that view.
Yes, she challenges this, arguing that law requires materiality for its very existence. It's visible, it's tangible, it's not just an abstract idea floating in a conceptual vacuum. There's no law without acts, challenging that fact-norm distinction central to Kilson.
So experiencing law is always situated within material contexts, places, objects, bodies.
Exactly. We live and experience law in specific places, in relation to physical objects, within particular landscapes. A materialist perspective encourages us to reconnect law with place and physical things, drawing on insights from socio-legal studies, legal geography, legal anthropology.
I'm focusing on relationships.
Yes, focusing on the complex relationality that governs human interaction not only with each other but also with the physical environment and our own bodies, the various ecological relationships of exchange, reliance, reactivity, resistance, parasitism, dominance, mimicry, and so on. It's about seeing law within that whole web.
Okay, let's move on to the distinction between inner and outer space in legal theory. What's the traditional understanding here?
The traditional understanding often involves a separation between, say, the law that governs our internal thoughts and beliefs, conscience, morality, perhaps the inner space, and the external objective law that is seen as existing outside of us, statutes, court decisions, the outer space.
And this is linked to time and space.
It's often linked to a time-space division, yeah. The individual is seen as this temporal being, moving through time, encountering a static external world where law exists as a fixed entity, like a map laid out in space.
So law is often externalized and spatialized in Western thought put out there.
Yes, there's a strong tendency to remove law from the subjective experiences of individuals and to imagine it as taking a fixed spatial form, something separate from us. But Davies argues for a more dynamic understanding of law as always in the process of becoming, always being made and remade.
So she questions that separation.
She questions this neat alignment of internal-external with time-space, suggesting that law can and does traverse these distinctions. It's not neatly inside or outside.
This connects to the idea of the mind as embodied and extended, doesn't it?
Precisely. Thinking of the mind as not just a separate thinking entity sealed inside the skull, but as embodied, deeply connected to and influenced by our physical bodies, and extended, reaching out and being shaped by our interactions with the physical world and other people.
Tools, environments.
Tools, environments, exactly. This challenges the idea of a purely internal realm of law. Normativity, in this view, doesn't just come from abstract rules downloaded into the mind. It emerges from our embodied actions and interactions in the world.
Davies uses Kafka's The Trial as a powerful, if unsettling, illustration of these ideas. How does that novel depict the relationship between inner and outer legal space?
Oh, The Trial is brilliant for this. Kafka creates this incredibly unsettling urban Gothic landscape to depict a legal world that feels both absolutely omnipresent, it's everywhere, and yet utterly irrational and inaccessible.
Law is everywhere and nowhere.
Exactly. Law seems to be everywhere. The law courts are famously in every attic, yet knowledge of it, understanding it, remains perpetually out of reach for the protagonist, K. It's both an idea that clearly exists and impacts him, and yet it doesn't truly exist in any tangible, understandable form. The inside of the law, the justice it supposedly represents, feels like an elaborate, terrifying illusion.
And this law seems to inhabit these strange, liminal spaces within the city, not grand courthouses.
No, not at all. Law in the trial is found in the unexpected interstices of the Gothic cityscape, a hidden court in an apartment building, endless anonymous corridors, seemingly ordinary but ultimately absurd everyday scenes like the flogging in the bank's lumber room.
And the spaces themselves are weird.
The very spaces of law seem to shift and distort reality. The interrogation chamber feels inexplicably larger than it should. Time seems to bend. Scenes repeat in unsettling ways.
And Kafka weaves together Kay's internal psychological state, his anxiety, his confusion with these bizarre external encounters with the law.
Yes, the novel brilliantly knots together the psychological, the corporeal. Kay gets physically weaker, the material, the social, and even the mystical elements of law as Kay experiences them. Law in the trial becomes this tangled conceptual web that resists any stable definition precisely because it is simultaneously an external object of his struggle and an internal, deeply personal and relational enactment of power and uncertainty.
And Davies argues that Western legal theory has often tried to avoid this kind of messy Kafkaesque dynamism.
Exactly. Western legal theory has often sought to stabilize these fluid, unsettling dynamics through processes of externalization, putting law out there, dephysicalization, treating it as purely conceptual, and spatialization of legal concepts, making them seem fixed and bounded. It tries to make law into a neat object abstracted from its physical locations and understood through static spatial metaphors, a move that geographers like Doreen Massey have critiqued for misrepresenting the dynamic nature of space itself. It tries to tame the chaos.
This brings us nicely to the concept of law space. What does that term encompass? It sounds like something from legal geography.
It is, very much so. Drawing on the work of legal geographers like David Delaney, law space refers to the idea that law is not just applied to space, like dropping rules onto a map. Instead, law is actively constituted by and constitutive of space. They shape each other.
Delaney said liberal law uses a lot of spatial language.
Yeah, Delaney noted how liberal legal discourse is particularly rich in spatial metaphors. Boundaries, domains, jurisdictions, spheres that are actually foundational to liberal legal thought itself. They aren't just decorative.
We use these spatial images of law all the time, don't we, without really thinking about it.
Absolutely. Think about boundary metaphors crossing the line, the way we map out global or national legal jurisdictions, even the very concept of legal scale, local, national, global. These aren't just convenient ways of talking about law, they actively shape how we understand it.
Like Jiren's boundary work in science.
Exactly like that. Jiren talked about how scientists construct spatialized knowledge defining what's in and out of science to establish their credibility by excluding non-scientific work. Similarly, the political field itself is structured by these kinds of spatial delineations. Religion, state, public-private, we draw lines.
And these spatial metaphors can have a significant impact on how we perceive abstract concepts like law, making them seem solid.
Yes, abstract concepts are often comprehended as something external to us through the use of spatial metaphors. And because we often think of physical space as relatively immobile and fixed, though geographers challenge that too, this can lead us to also see these spatialized concepts, like law, as solid, stable, and unchanging.
But critical theory pushes back.
Right. Critical theory challenges this fixed view by emphasizing the ongoing work required to maintain these boundaries, the exclusions that are inherent in their creation, the temporal dynamics at play, they change over time, and the often blurry and indeterminate nature of the supposed divide between inside and out. It forces us to question the very boundary between our interior experiences and the external spaces around us.
And this insistence on exteriority and objectivity putting law out there can have other consequences, particularly in relation to embodied experience, right?
Exactly. This spatialization is often accompanied by an insistence on the exteriority and objectivity of knowledge, effectively removing concepts like law from the realm of lived, embodied experience.
The body gets left out.
The body gets left out. Think of the dualisms that feminist philosophers like Genevieve Lloyd and Elizabeth Gross discuss in relation to thinkers like Irigaray and Kant, the separations between space-time, exterior-interior, and body-mind. These dualisms are often implicitly gendered.
How so?
With time, the masculine and culture being privileged over space, the feminine, and nature. This framework often dictates that only the supposedly disembodied, rational subject, traditionally coded masculine, can truly know objective reality.
So embodied subjectivity, lived experience, gets erased or devalued in this model.
Precisely. Knowledge, including legal knowledge, is figured as this detached, disembodied thing, bringing knowledge and therefore law back to the self re-embodying it. Recognizing its connection to our lived reality becomes a crucial task, particularly for feminist thought.
Like Patricia Watson said.
As Patricia Watson aptly puts it, the law is who we are also the law. It's not separate. And Lefebvre makes a fascinating point, arguing that even in modern societies, much like in so-called archaic societies, we often obey norms spatially without even consciously recognizing them as such. The layout of our cities, the design of buildings, fences, pathways, all these guide our behavior in ways that feel natural or inevitable, but are actually normatively structured. We follow the spatial rules.
Let's now turn to the idea of the scales of law.
Yeah.
How does thinking about scale help us understand the complexities of law?
Well, examining how both formal and informal law operate across different geographical scales, from the very local, like a neighborhood or family, up to the global level, helps us to understand the dynamic and multi-layered nature of legal systems.
It's not just one level.
No. The concept of scale highlights how legal complexity, plurality, and different ways of being subjected to law are generated through these interactions across different levels. It offers a way to analyze how law moves and operates between subnational, national, transnational, and international spaces. It adds another dimension.
And our perspective or standpoint, where we're looking from, also plays a crucial role in how we understand law at these different scales, doesn't it?
Absolutely. The very way we come to know and understand law, it's onto epistemological constitution. How it comes into being for us happens not just through abstract reflection and trying to be objective from some God's eye view. It also happens through our subjective engagements with the world from our particular position.
Like the flat earth example.
Right. Think about the difference in perspective between someone who believes the earth is flat and someone who understands it's spherical. Their entire understanding of geography, politics, everything is fundamentally different based on their perspective or scale of understanding. This challenges the assumption that more objective or abstract knowledge, zoomed further out, is always superior.
So standpoint matters.
Standpoint matters. Feminist and critical theory, for example, often aim to re-embed the human within the world, valuing the importance of standpoint and context, and emphasizing the mutual shaping of subject and object in the process of knowing. Knowledge is situated.
So different representations and different choices of scale can lead to very different understandings of law. It's not neutral how you frame it.
Exactly. Representations are never neutral. They're always chosen, often strategically, and there are always diverse scales at which we can analyze a phenomenon. These different scales and the pluralities of situations and perspectives, they reveal animate alternative experiences of law.
And scale itself can be political.
Oh, definitely. Scale isn't just a neutral measure of the real. It involves normative and political choices, and is often deliberately manipulated for political ends. Think of the feminist strategy of downscaling politics to focus on the personal. The personal is political.
Or the Parthenon marbles debate.
Right, or the British Museum's arguments about the scale of cultural heritage, universal versus national, in relation to the Parthenon marbles, or even the discourse around global terror, which operates at a particular scale, global, to frame certain events and justify certain actions.
And discourse itself, how we talk about scale, is deeply intertwined with the construction of scale.
Yes, exactly. Discourse isn't just about describing different scales that already exist out there, it actively constitutes them. So instead of just thinking about jumping scales as if they were pre-existing levels on a map,
We see how language creates them.
we need to recognize how rhetoric and language themselves construct the very spaces and scales we are talking about. While observers do imagine and construct these scales, they are also always uniquely situated within their own experiential engagements. We're always looking from somewhere.
Santos's map of misreading offers an interesting, if maybe counterintuitive, way to think about these different legal scales, doesn't it?
It does. It's provocative. Santos divides the legal world into local, which he actually sees as large-scale legality because it encompasses the diverse, detailed norms of everyday life.
Okay, so large scale means close up.
In his framing, yes. Then national, the medium scale of state law, and global, which he characterizes as small scale due to its often limited direct impact or detail compared to local life.
Interesting inversion.
It is. And he argues that different forms of law operating at these different scales actually create different kinds of legal objects. They use different criteria to determine what details are meaningful, what features are relevant, establishing different networks of facts, and therefore different legal realities depending on the scale you adopt.
And Santos's aim in doing this is to broaden our understanding of what counts as law, moving beyond just the state.
Precisely. His objective is to open up the definition of law in connection with legal pluralism and informal law. He wants to demonstrate that the state doesn't have a monopoly on defining what constitutes law in society.
So shifting perspective reveals different laws.
Yes.
Yeah.
By shifting our perspective away from the nation-state as the primary or only lens, we can start to see law as a different kind of object, one that is shaped by other mechanisms, universal human rights norms, our relationships with the natural world, ecological law, or informal social connections within communities, customary law.
But it's important to remember that there's no completely neutral outside perspective from which to view these different scales, right? You can't just float above it all.
Exactly. That's a crucial caveat. While we might try to step outside the mosaic of legal scales to gain a broader view, there is no absolute outside position. We are always situated somewhere.
And law isn't just static systems.
No. The plurality of norms is constantly being generated and performed by human subjects in their ongoing engagements with each other and with the material world. A purely descriptive approach to legal pluralism, just mapping the systems, can sometimes inadvertently objectify these dynamic relationships and personal engagements that actually constitute our experiences and constructions of law. It can miss the lived reality.
Even choosing a scale is an act.
Right. Even the seemingly objective act of a geographer choosing scales for data collection can be a political intervention, highlighting certain aspects of reality while obscuring others. This contrasts with conventional legal analysis, where the frameworks often appear fixed by positive law or longstanding custom. And ultimately, jurisdiction plays a critical role in the formalization of law, defining the who, where, what, when, and how of legal authority at different scales. Jurisdiction is about drawing lines based on scale.
Okay, let's now consider the role of subjects and perspective in understanding law. What's been the traditional view in jurisprudence about whose perspective matters?
Well, the traditional view, particularly within modernist and positivist jurisprudence, has been pretty clear. Any legal system worthy of serious study is fundamentally tied to a state. Full stop.
And legal theory developed accordingly.
It did. Legal theory in this dominant view has largely been established by defining and limiting the concept of law to the law of the state, thereby actively excluding alternative conceptions and normative orders as either not law proper or less important.
And this development happened with a very specific focus and viewpoint, didn't it? A particular kind of subject in mind.
Exactly. Legal theory developed with a particular scale in mind, the institutionalized legal system of the nation-state, and crucially from a specific perspective, that of a detached observer who possesses an internal understanding of state law. Typically, this meant a lawyer, a judge, or a legal scholar trained in that system.
So this created a kind of closed loop, almost self-reinforcing.
Pretty much, yeah. A closed circle where legal experts operating within this state-centric framework tended to devalue and exclude both non-state forms of law, like custom or indigenous law, and the perspectives of those who weren't legal experts, the so-called layperson.
So this methodological statism we discussed earlier also led to a very narrow perspective within legal theory itself.
Precisely. This methodological statism, coupled with this monovocal expert perspective, significantly narrowed the scope of meaningful debate about the very concept of law throughout much of the 20th century.
What happened to the layperson in this?
The layperson, in traditional legal theory, was almost defined out of existence when it came to having any meaningful knowledge or understanding of the law. Their perspective just wasn't considered relevant to defining what law is.
And this limited idea of law was reinforced in various ways, institutionally.
Yes, positivist legal theory consolidated this limited view through a combination of abstract, expert understandings of law and exclusionary philosophical and pedagogical approaches, how law was taught, how it was written about. This resulted in a threefold reduction, you could say, of those considered to be legitimate knowers of law.
That's the threefold reduction.
First, only experts were seen as truly knowledgeable. Second, their expertise was largely limited to state law only. And third, their perspective was often assumed to be abstract and detached, not materially situated in lived experiences.
How does legal sociology offer a different approach to perspective? How do they see the knower?
Legal sociology, as scholars like Roger Cotterill have argued, offers a more mobile perspective. It's characterized by a movement between internal and external attitudes towards law.
Inside and outside at the same time.
Kind of, yeah. It emphasizes the mobility of the observer and the porousness of legal boundaries. Sociological insight involves being simultaneously inside legal ideas, understanding how participants see them, and outside them, analyzing them as social phenomena, sometimes speaking through legal concepts, sometimes speaking about them.
There's a metaphor of law as a house that helps illustrate these different perspectives, doesn't there? Can you remind us of that?
Yes, it's a useful image. Imagine law as a solid house with different kinds of legal spaces inside, maybe the courtroom, the legislature, the police station, the family home, and different distributions of power within it.
Okay.
The traditional legal theorist, in this metaphor, often occupies the main living room, trying to gain a comprehensive, coherent view of the entire house from that single vantage point.
And the sociologist.
Sociologists and anthropologists are more like people moving between the different rooms, maybe even going into the basement or the attic or looking at the house from the garden outside. They offer more complex descriptions of the interactions and dynamics at play in these various spaces and how they connect or conflict.
And critical theorists.
And then you have critical theorists, feminists, indigenous scholars who might be launching attacks or asking fundamental questions about the very structure of the house itself. Are the foundations sound? Who built it? Who gets excluded? They might be trying to renovate it or even suggest we need a different kind of dwelling altogether. They challenge the structure.
And crucially, these different theoretical interventions aren't just observing law from a distance, they're actively shaping it, aren't they?
Exactly. That's a key point Davies emphasizes throughout. Theoretical interventions, including traditional legal philosophy, are in constant dialogue with and are constitutive of their objects of study. The very concept of law, as we understand it, is shaped, though not solely or causally, it's more complex than that by legal theory itself.
But it's not just theorists defining law.
No, absolutely not. Davies emphasizes that materially situated law, how law is actually experienced and lived on the ground, is constituted by all legal subjects, not just the theorists or the experts.
And that's where pluralism comes back in.
Right. This is a core insight of legal pluralism and legal consciousness studies that beyond the expert, ordinary people know and live law in a multitude of ways. They experience it as pathways, limits, resources, connections within their specific social and material environments.
And this material plural diversity within law is deeply connected to the idea of legal subjects or persons who gets counted as a subject.
Yes. Traditional legal theory often focused on the idea of the reasonable man as a supposedly neutral and objective standard for legal reasoning.
The objective standard.
Supposedly objective, but feminist legal theory, for example, has powerfully demonstrated how this seemingly neutral standard actually reflects the perspectives and experiences of privileged individuals, often white, propertied men.
And the result?
The result was often legal frameworks and decisions that marginalized others, constructing women, for instance, as secondary or inherently different within the law. Feminist legal theory showed how state-based legal reasoning often relies on these unexamined, gendered assumptions and fantasies of privileged men.
But Davies also notes feminist theory maybe didn't always focus on reconstruction.
Right. While brilliant at critique, she suggests feminist theory has perhaps less frequently focused on the next step, how law might be actively reconstructed or performed in different, more equitable ways, though that's changing too.
This brings us back to the idea that normativity and law are performative, that acting as if is important.
Exactly. Law, as a conceptual object, is in many ways an effect of our everyday practices. It exists as an ideational object, a mental image we carry around, largely because we constantly act as if it exists as this independent thing.
And our actions support the idea.
Right. This mental image is supported and reinforced by our material actions going to court, signing contracts, obeying traffic lights. Even Kelsen, the arch formalist, eventually recognized that the basic norm, the ultimate foundation of a legal system, is essentially a fiction. It's something we presuppose and act upon at every level of legal action and interpretation to make the system work.
We treat it as real.
We constantly behave as if law has an independent reality, rather than recognizing its fundamental reliance on ongoing human belief and action. The image we hold of law informs our practices, and in turn, our practices sustain that very image. It's a feedback loop.
And Davies wants us to move beyond focusing solely on human society when thinking about law, to include the non-human more explicitly.
Yes, she encourages us to consider the material depth of our existence and the inherently mixed nature of the networks in which we are embedded, the complex human, non-human networks that shape our world.
Why is that important for law?
While acknowledging the agency and role of the non-human in human contexts adds weight to important ethical shifts, like recognizing the value and even the rights of nature or animals, or the need for environmental stewardship. It pushes us beyond anthropocentrism.
Recognizing our dependence.
Exactly. Our very existence is rooted in material space and time. Humans are not separate from or superior to this reality, but are fundamentally reliant on their ecological and material contexts. As some environmental thinkers put it, perhaps we should think of the Earth as ultimate jurisdiction.
This also involves recognizing a kind of agency in the non-human world itself, not just seeing it as passive resources.
Precisely. Physical objects, ecosystems, locations can be conceptualized as existing beyond ultimate human control and as exercising their own forms of agency, as explored in actor network theory and new materialism. We coexist in a world populated by both human and non-human actors.
But how do non-humans act?
Living non-human entities relate to each other and to us through various means: resisting, adapting, reproducing, mimicking, exchanging materials and energy. And even non-living things, mountains, rivers, technologies, are implicated in these complex material semiotic networks that shape our world and potentially our understanding of law.
So agency here is used broadly.
Yes, the strategic use of the term agency in non-human contexts serves to underline the point that humans are not just subjects acting upon a passive world. We are also, in many ways, objects within the broader systems of the Earth, subject to its forces and processes.
Okay, let's turn our attention now to metaphors and meaning. Davies argues that our thinking itself is inherently metaphorical. We can't escape it.
Yes, she argues, drawing on people like Susan Hack, that thinking, conceptualizing, and the very act of abstraction are necessarily metaphorical processes. We understand abstract ideas largely through concrete comparisons.
But wasn't metaphor seen as dodgy in philosophy?
Historically, yes. Early English philosophers like Locke, Hobbes, and Mill were often quite critical of the philosophical use of metaphor. They viewed it as illegitimate, potentially clouding truth, appealing to emotion rather than reason.
Locke said it was deceptive.
Locke saw it as an appeal to emotion. Hobbes saw it as potentially deceptive, leading thought astray.
Yet Davies points out that they themselves use metaphors constantly in their very condemnation of it.
Exactly, it's quite ironic. Hobbes used the analogy of a bird caught in lime twigs to describe the entrapment of the mind by deceptive language. And the Leviathan itself is arguably the most famous metaphor for the state in political philosophy. They couldn't avoid it.
So attitudes changed later.
By the 20th century, there was generally less outright hostility towards tropes, but some still viewed metaphor as a kind of optional extra, something extrinsic to the core of philosophy. Useful perhaps for explaining already formed ideas like Plato's famous cave allegory, but not essential to the thinking itself.
But other philosophical traditions see metaphor as much more fundamental, as unavoidable.
Yes, continental philosophers in particular tend to see figurative language as deeply ingrained in the very fabric of language and therefore unavoidable in our thinking.
Nietzsche's army of metaphors.
Right. Nietzsche famously described truth itself as basically a mobile army of metaphors, metonyms, and anthropomorphisms that we've become so accustomed to that we no longer recognize their metaphorical nature. We forget their constructions.
And other views give metaphor more specific functions within philosophy.
Yes. For instance, Michel Ledoux argued that philosophical images often point to critical tensions, unspoken assumptions, or contradictions within philosophical texts, places where the argument breaks down or relies on something unstated. Recall Derrida's exploration of the pharmakon in Plato, a word meaning both remedy and poison, revealing a deep ambiguity.
So metaphors can reveal problems.
They can reveal problems, yes. This perspective denaturalizes the idea of a single plain truth, situating it instead within linguistic and rhetorical constructions. Images in this view can be both philosophy makers, helping build arguments, and philosophy breakers, revealing their weaknesses.
And the choice of metaphorical language can reveal and even contribute to broader shifts in our thinking over time.
Precisely. The kinds of metaphors that are dominant or emerging can indicate and even actively contribute to conceptual and cultural transitions. For example, a shift from thinking about law primarily using hierarchical metaphors like a pyramid or chain of command to using more horizontal or networked metaphors like a web or rhizome.
And theorists can consciously use metaphors to try and shift understanding.
Absolutely. Theorists can strategically emphasize certain metaphors in their work in order to influence conceptual change, to encourage people to see law or society differently.
Davies gives several examples of these kinds of metaphors used to describe law, moving beyond the simple command or rule idea.
Yes, she highlights quite a few. Max Weber's Web of Law, Sally Falk Moore's Semi-Autonomous Social Fields, Deleuze and Guattari and Latour's Assemblages, Deleuze and Guattari's Rhizome, Boaventura de Sousa Santos's Flotillas of Law, Latour's Networks, and Andreas Philippopoulos Michalopoulos' Lawscapes. Each metaphor offers a different way of visualizing and understanding the nature and operation of law, its connections, its fluidity, its spatiality.
She also touches on the historical connection between oikos, household, and nomos, ordering law. What's the significance there?
Yes, that connection highlights the original sense of law, as Hannah Arendt discussed, as being primarily concerned with relationships and order between households or communities rather than solely emanating from a central state. And again, spatial metaphors in law often frame those fundamental inside-outside distinctions that are so central to legal thought, territory, jurisdiction, even the idea of the self as a bounded entity. The boundary itself becomes a defining feature of both law and the liberal conception of the self.
The state is also frequently imagined through metaphorical language, like the body politic.
Absolutely. The state is often imagined as a body politic, most famously in Hobbes's Leviathan. However, Kelsen, the positivist, famously criticized this kind of personification of the state as a form of animistic superstition, arguing for a much more abstract and formal understanding.
But the metaphor influences how we see individuals, too.
Interestingly, yes. The qualities attributed to the state in these metaphors, being autonomous, rational, self-legislating, are often then read back onto the ideal individual person, reinforcing that model of subjectivity.
Property also seems to function as a kind of metaphorical bridge here, connecting the person and the state.
Yes, property serves as a crucial conceptual bridge, linking ideas of spatial limitation, my property boundary, territoriality, the state's territory, self-possession, owning myself, and control over one's body, labor, and freedom, as Jennifer Nadelsky has discussed. It ties the individual to the spatial logic of the state.
But law and geography scholarship is actively disrupting this traditional distinction between abstract law and physical space, taking what's called a non-representational turn. What does that mean?
It means moving beyond seeing space as just a passive container or backdrop for law. This approach emphasizes that space isn't just represented by law, but actively acts upon and is an integral part of law. It's a two-way street.
And property law is a key example.
Property law is a prime example of law's significant impact on physical places, often through processes of abstraction, treating unique places as interchangeable units, fungibility, making them easily exchangeable, and dephysicalization, separating legal rights from the physical reality of the land. Graham's concept of lawscape explores this.
Indians can disconnect law from place.
Yes, it can lead to treating all spaces as legally the same and human life as somehow separate from the specific places where it is lived. This sometimes had destructive consequences, particularly in colonized areas where abstract European property law was ill-suited and imposed over existing place-based indigenous legal systems.
So there are other ways to relate law and land.
Absolutely. Indigenous cultures often offer a different model, one with a more responsible and reciprocal relationship between persons and land. This points, as Graham suggests, towards the possibility of a more adaptive notion of property and law more generally, where the specific characteristics of a place matter in normative constructions. Law needs to be grounded.
Okay, finally, let's explore the metaphor of pathfinding. How does this differ from the more common metaphor of boundaries?
Well, the boundary metaphor, as we've discussed, typically evokes the image of imposed lines, static divisions. That aligns well with a view of law as a set of commands issued from a central authority defining zones. Boundaries of formal law imply the positive creation of a specified zone, territorial borders, property lines, colonial divisions.
Empaths.
The path metaphor, on the other hand, suggests practice, movement, and iteration, the idea of going over something repeatedly. It emphasizes custom and the way things become established through use over time, although, of course, some paths are also imposed from above, like highways.
And this challenges Western separations.
Yes, Western ontology often separates law, land, people, and culture into distinct categories. Relational and materialist perspectives, which the path metaphor resonates with, challenge this separation, seeing them as interconnected.
So can we actually think of literal physical pathways, roads, trails, as a form of law? Is that what she means?
That's the provocative question Davies poses, using the literal path as a metaphor to explore deeper ideas about how norms emerge. She suggests thinking of law as ingrained in the land itself, like a sheep track, something that emerges, as Davina Cooper puts it, as a consequence of multiple beings repeatedly traversing a particular route.
Following the contours of the land.
Exactly. These tracks might follow pre-existing contours worn down by animals over time, showing a way to go. Importantly, the colonization of animal tracks or indigenous pathways by imposed human road systems often led to the destruction of both the land and existing indigenous lawways, which were often tied to those paths.
So paths reflect different ways law comes about.
Right. Planned roadways and beaten tracks can be seen as reflecting both de jure, imposed law, the plan, and de facto, usage-based law, the track worn by feet, ways of establishing pathways. Both create paths that become normative simply through their existence and use.
Where does the normative element come from in a physical pathway? How does a path tell you what you ought to do?
Well, the normative element can arise either from an explicit directive, a sign tells you use this path, or simply from the repetition of usage. Sarah Ahmed talks about how the repetition of bodily actions over time creates a bodily horizon, making certain objects and routes more accessible and reachable than others.
It becomes the easy way.
It becomes the easy way, the path of least resistance. These repeated actions create routes where the way to go is laid out, becoming normative in the sense that deviating requires conscious effort and maybe feels wrong. In analytical philosophy, a path can even be seen as a reason for action.
But we don't usually call a footpath.
No, it might not be a common European habit to think of physical pathways as law in themselves, but they certainly possess normative elements. They guide behavior, and they are often mandatory in state-imposed systems, like staying on the road.
And our individual choices of roads, repeated over time, can also become a kind of personal law, a habit.
Exactly. Choosing a preferred route, maybe because it's shadier or has better footing or is just familiar, and repeating it embeds it as a habit. It becomes routine, normal, and ultimately normalized. It could even be considered a form of personal law.
But state law often restricts this.
Yes, state property law often limits our free choice of route, imposing restrictions on where we can and cannot go through fences, no trespassing signs, etc. Interestingly, as Indigenous scholars like Irene Watson point out, Aboriginal songlines, which embody law and our paths across country, continue to exist within colonial landscapes and under colonial law, representing a plurality of law paths that are not always visible or perceived by the dominant legal system.
This idea of pathfinding seems to have a transformative potential, challenging fixed structures.
Yes, the transformative element of performance or pathfinding challenges traditional dichotomies like structure versus agency. Am I just following the path or making it? And inside versus outside. Is the law the path itself or the rule about the path? Thinking of law as pathways challenges the idea of law as a separate container or boundary that simply shapes people from the outside.
Law depends on the walking.
In this sense, yes. The very existence of law becomes dependent on the action of following these pathways and can be potentially transformed by the adoption of different or new practices, forging new paths, or refusing to follow old ones. The inside-outside distinction of law becomes more contingent and even illusory if law is fundamentally constituted by our movements through space and time.
So the path metaphor offers a different way of understanding the relationship between law and time and space compared to boundaries.
Absolutely. The path metaphor brings together the temporal, it takes time to make a path, time to walk it, and spatial dimensions of law in a way that the boundary metaphor, with its emphasis on static spatial divisions, often does not. A pathway is made through use over time, introducing a crucial temporal dimension to law and suggesting that it emerges from relationships and repeated actions rather than being simply imposed from above at one point in time.
Paths also imply connection.
Right. Paths inherently indicate connections between places and people. They have beginnings and ends, implying a kind of directionality or teleological character, even if it's just getting from A to B. Iterated legal acts, like filing forms or following procedures, are often undertaken to achieve a specific purpose efficiently by following mandated or established routes, legal pathways.
And they connect individual and collective.
Yes. Paths can be established individually or collectively through repeated practice. The path connects collective patterns with individual action. Individuals follow normalized patterns, reinforcing them. It offers a material way of thinking about being in the world with others in the physical environment.
And even inner pathways.
Yes, it's also worth noting that pathway is a common descriptor of neurological patterns, habits of thought, ingrained responses. This suggests an internal law that governs our ability to be and make meaning. So the pathway can be both a literal physical thing and a powerful metaphorical tool for enriching our legal thought across different dimensions.
Okay, so in the conclusion of Law Unlimited, Davies brings together these threads of materiality and plurality that we've been discussing.
Yes, she really synthesizes the argument. She reiterates that the book's central concern has been to explore the materiality and plurality of law, moving beyond traditional limitations.
And her starting point was key.
Her methodological starting point was crucial. Deliberately imagining law without the preset limitations often imposed by traditional legal philosophy and pedagogy.
Like what limitations?
Things like the unquestioned centrality of the state, the idea of law needing to be a unified system, the dominance of the legal profession's perspective, the absolute necessity for a single concept of law, and the pervasive assumption that law is fundamentally immaterial, just ideas or rules.
So unlimiting law meant actively questioning these ingrained assumptions, pushing against them.
Exactly. It meant challenging the idea that law is inherently abstract and unified, and instead exploring its tangible material aspects and its inherent plurality, many ways it manifests.
And she sees materiality and plurality as linked.
Yes, Davies argues that materiality and plurality are deeply interconnected. Both emerge from a view of the world that emphasizes particularity, irregularity, dynamism, and complexity, rather than abstract universals and static order.
So where is law then in this view?
From this perspective, law as a theoretical object isn't confined to one place or form. It's all over or ubiquitous. It's present in our relationships, our practices, the spaces we inhabit, our individual experiences, and crucially, as a ceaseless process of constructive movement. It's always being made.
And traditional legal theory often misses this multidimensionality, this ubiquity.
Right. Orthodox legal theory, with its persistent focus on finding a singular, static concept of law, often reduces this rich multidimensionality down to one simplified model.
But concepts can be useful.
Oh, absolutely. Davies acknowledges that these frozen concepts can be useful as temporary analytical tools, ways to get a handle on things, but she reminds us that they are just momentary stopping points in the ongoing process of conceptual experimentation and understanding.
So a concept of law is just one perspective.
Exactly. A concept of law, she argues, is ultimately just a particular perspective, a way of bracketing certain variables for the purpose of analysis. It's never an end in itself or a complete and exhaustive framework that captures the whole reality.
So, the history of legal theory shouldn't be seen as a failed attempt to find one perfect definition of law that has eluded everyone.
Precisely. Davies suggests that it's more accurately, and perhaps more productively, understood as a history of ongoing experimentation with the very idea of law, trying out different concepts, different metaphors, different frameworks.
And forming concepts isn't always deliberate.
No. Concept formation can be an intentional process, but it also often happens organically, emerging from practice. Researchers play a role in crystallizing truth or understanding from a more inchoate substratum, a messy reality, rather than simply discovering pre-existing Platonic forms or inventing concepts out of thin air.
And empirical work itself is part of this making.
Yes, importantly, empirical work itself is performative, as Law and Uri argued. It actively shapes the sociological reality it seeks to describe just by observing and reporting it in a particular way.
Reality isn't fixed.
Reality, in this relational view, is not a fixed entity out there waiting to be discovered. It's better understood as a relational effect, something constantly being produced and stabilized and destabilized through material social interaction.
So what constitutes law for Davies, ultimately?
Davies' book ultimately promotes the idea that a wide range of these relational effects produced through human actors interacting with their ideas about law, their embodied existence, and their situatedness within a reactive physical world are what constitute law in its broadest, unlimited sense.
So, to recap then, we've explored the limitations of thinking only about traditional state-based legal concepts.
Right, and the importance of considering materiality, the physical world, bodies, spaces, and plurality, the existence of multiple normative orders.
We looked at the dynamism of concepts themselves, how they change and can be changed,
Uh-huh. And the performative nature of theory, how it doesn't just describe but actively shapes reality.
and the crucial roles of space, scale, and perspective in understanding how law operates and who gets to define it.
We've certainly covered a lot of ground, looking at some really intriguing specifics like the idea of law showing up in unexpected places, neurological pathways, physical environments.
And that challenge to the basic subject-object distinctions we usually take for granted.
And the whole idea of unlimiting law, trying to see it fresh.
And hopefully, as you, the listener, have followed along, considering these broader perspectives helps make sense of how rules and norms function in the world in maybe a more nuanced way. It's not always simple.
Yeah, hopefully it provides some tools for thinking, maybe makes things feel less overwhelming by showing the complexity isn't a flaw, but maybe inherent to law itself.
We want to leave you with a final thought, echoing Davies' conclusion. Perhaps the history of legal theory isn't a story of failure to define law perfectly, but rather a continuous and ongoing experimentation with its very essence, its possibilities.
So the question becomes, what else could law be beyond the conventional boundaries we often take for granted?
It's an invitation to consider how these ideas about unlimited law might resonate in your own areas of interest, or maybe connect back to the sources that initially sparked your curiosity about this topic.
It's definitely an invitation to continue exploring the possibilities, to keep asking those fundamental questions about what law is and what it could become.